both of you. My name is Joshua Smith, and I will be your mediator today. I would like to thank you both for coming, and before we get started, can we introduce each other? All right, and you, sir, your name is Bob. Nice to meet you, Bob. And you, ma'am, your name is Melissa. Nice to meet you, Melissa. Well, thank you both for coming today. I understand that this is a court-appointed mediation, but it really talks on both of you to have this accountability to come today and still give this a try before you actually go to trial. And before we get started, I would just kind of like to explain the role of me, the mediator. My role is one that is facilitated. That means I'm not here to push either of you into reaching one side or one argument or one agreement from my point of view. It has to be an agreement that both of you choose, and it's mutually acceptable between you two. That being said, I'm supposed to be a neutral mediator, which I assure you guys I will try my best to do this. I will sway away from any potential biases that might be with one party or the other. And now, I would like to explain to both of you quickly what the stages of mediation are. So one of the stages we start with is where we begin with the plaintiff. The plaintiff, in this case, would be you, Bob. So we'll begin with your side of the story here in a little bit. Then after Bob, our plaintiff, is done speaking, you, Melissa, our defendant, will then tell us your side of the story. This way, we get the sides from both parties here, and we can hear each person's perspective on what actually occurred and what we need to do about this. The next stage is where we will ask both of you guys to identify your potential concerns. We will hear what you think is in the best interest of both parties, and ultimately we'll try to mutually agree on what the issue is here and how we can probably come about solving this. Third and finally, we will brainstorm and propose potential solutions. This, remember that ideally we're trying to get a solution in which both parties are satisfied, that both of you guys come about to reaching the agreement. And this also goes along with my role of being a facilitative mediator, in which I'm here to try to help you guys discover what it is that will bring you two together and find this agreement. But I can't give you guys the answer. I can't openly just give my side of the story and what could solve it. I have to find that agreement is something that you both see value in and you would like to do. Then finally, if we actually do get this to where we can write the agreement, we will put it in a contract, and then you guys will mutually agree that this is what will occur, and everything from there should be good to go if we follow up on those promises in good faith. Cool. Next, I would like to explain to you both a little bit about the confidentiality within mediation. There are certain times in which me as the mediator are not allowed to go forward to a court or any other people to explain some of these processes. That's most of the time. But there are also times in which I would have to disclose some of this information to a court, and full confidentiality will let me explain to both of you that I need to show you guys what those times are. So I'm going to pull it up right here and read it aloud to both of you. If you both were to sign the mediation in agreement saying that a court or an outside force may discover what occurred in the mediation, that is one of those times. If there's something said in the mediation that is a part or open to the public, where it's public information, anyone can grab that information, I can't personally promise that that information might not get out. You guys really can't be held accountable to promising that either. So that's one of those chances where something's already disclosed and then it just happens to be said within the mediation too. Another example of a time when I can't withhold information would be if one of you two was to make a threat towards the other party or towards me, or if there was some sort of promise to do something illegal. And these things are necessary for courts to hear, and if I've heard it, unfortunately, I'm going to have to disclose that to a court. Let's just refrain from these things anyways. Let's see here. if there is a mediation used that intentionally is meant to hide a crime or used to conceal a crime, and I was to discover any of this information and it was criminal, I would have to report this to a court as well. Okay? And there's not that many more. There's one or two more, which I'm not certain that'll come up in this mediation, but in case it was, the issue of child abuse, I will have to report for either party. So if this was brought up and I heard it, then I'm just gonna have to disclose it. Let's see here. There is one other that is known as malpractice, and this reflects more so on me, the mediator, than you guys. Malpractice is when I intentionally would skewer or be completely against another party. This is when an outside court or a force can hear this mediation and understand those concerns, which we're not going to let that happen. And now I'm going to explain to you both what a caucus is. So a caucus generally is when a mediator would call upon this to both of you, and a caucus is me asking for personal one-on-one time to talk to one of the parties. By doing this, I feel as if we can facilitate the mediation in a direction where we can hear the side of the story from this party compared to having both parties present and one person not disclosing as much information that they normally would if it was just them talking to me, the mediator. So if I was to call upon a caucus, the other party that would initially go out will wait outside until our caucus is over, and I will let you guys know who I would like to caucus with first. And to be fair, we would like to caucus with both people, so you will also have a time to talk with me one-on-one if a caucus is called. So if you guys have any questions about caucus, I would greatly like to hear them as well. And personally, I know that sometimes the mediator is meant to call the caucus, but I want you guys to feel as if you have the right to call a caucus too. So if at any time there is something on your mind which you feel you would like to disclose personally with just me, the mediator, that you feel might necessarily facilitate the mediation and help us gain a better understanding of what exactly is going on, then please request a caucus, either one of you. And hopefully, if you guys are willing, then we will have an agreement to where the person will be respected that called upon the caucus. So if one of you guys needs to talk one-on-one for a time, we'll be polite and respectful and understanding to that. Thank you. Then there's one thing that I'd like to explain regarding confidentiality. The thing with caucuses is whenever I'm to talk one-on-one with either party, anything said in that caucus will remain within that caucus unless the party was to tell me specifically that they want that information to be disclosed to the other side. This is me as a mediator keeping the promise that what is said between us stays between us. So it's going to stay that way. Thank you guys. And now I would like to read both of you the mediation consent form, and you guys will agree to sign this if you're willing to do this, which is court ordered. So I will read it to you. I understand that all files and notes of our mediation and its mediators are confidential. There are exceptions to this rule. A mediator can be compelled to testify about the mediation in cases involving juvenile abuse, neglect, or dependency, abuse, neglect, or exploitation of a disabled adult, disciplinary proceedings before the NC State Bar, felony trials, and criminal acts, violence, or threats of violence made during the mediation that endanger a person or property. If the parties reach agreement, we will forward the dismissal form to the district attorney once applicable fees are paid. I agree that I will not hold our mediation services responsible for any agreements made or failure to reach an agreement during this mediation. I understand that mediators are neutral parties and cannot give legal advice or assist in a case. I further understand that mediators will give no opinion regarding the legal effect of this consent to mediation or any agreement that is reached as a result of the mediation. If I have a legal question, I may request a continuance of the mediation in order to consult with an attorney of my choice. I understand that the mediators and staff have judicial immunity from any civil action except the case of willful or wanton neglect. I understand that weapons and physical conflict are not permitted during the mediation. I also understand and agree that the mediation retains the rights to report any crimes committed on the premises. And that is our consent form. It somewhat went over some of the ground rules that I gave earlier and some of the exceptions to when I will disclose any confidentiality. But if you guys need to read over this as well, then please take your time reading this and then sign. Thanks. And finally, before we begin our mediation, I would like to go over a few ground rules. So the ground rules that we all must agree upon are that one person speaks at a time. We don't want to keep interrupting each other. We don't want to be disrespectful to another person who is trying to keep their mind open and disclose their information. And you guys are meant, another ground rule is that you guys are meant to talk to me initially. So before you guys really get deep within your own conversations to one another, you should initially disclose your information to me, the mediator. That way I can help facilitate the process. Then another ground rule is that there's no weapons, which you signed your consent form seeing that there was no weapons. So if either of you have any weapons now, it would be a great time to hand those over. Oh, okay. Thank you. And now we need all cell phones off. So if you happen to possess a cell phone, you must turn it off. Which, if you guys would like to, we can also put that in the table so we ensure that they're gone and that they're not really there to distract us within the mediation. Oh, okay, thank you, sir. Then we will be very respectful and polite to each other during the mediation. Please try to hold back any intense feelings in which you would really think that these would hurt the other party. Try to put yourself in the shoes of the other person before you say something too, because you both have different perspectives as to what has happened. But we are trying to be polite, and ultimately this mediation will go a lot smoother if everything is like really grouped between us and have a good relationship between us all. Thank you. And is there any other questions between you two? Okay, let's discuss a time frame for this mediation. Mediation is typically seen as a faster way for alternative dispute resolution to come about. So I would say for this mediation, it might take us about 2 hours. Does 2 hours sound agreeable for both of you? Okay, great. Well then let's get started.